people. Great, thanks and welcome everyone. We're really excited to do this continuing legal education event about the state of coal ash protections and get an update on how we're going and where we are at on coal ash from the absolute foremost expert on these issues in Illinois. I have been really excited to work with Jenny Castle on this work. I'll just give a little bit from her bio. She's a senior attorney with Earthjustice's Clean Energy Program based in Chicago, and she's focused on legislative, regulatory, permitting, and litigation matters concerning coal ash pollution, as well as other pollution and transitioning to a renewable energy economy. She's a graduate of Northwestern University School of Law. She also co-led negotiations on fracking as well. Illinois' fracking regulatory law that has not allowed any fracking yet. Still watching it. But for those of you around who want to get continuing legal education for as an attorney in Illinois, I'm putting this little thing in. You also can email me. Please just put your ARDC number in. It's a Google Doc. Don't interfere with anybody else's. Put your information in, and we'll get you the CLE certificate within the week. And we do have another one of these that we've worked with on Earthjustice for next week on the 20th. And really excited about that one too, about a hot mix asphalt plant. So if you are an attorney, you'll get an hour from both of these, but please make sure to put your AFDC number in there. I'll also follow up afterward, but this is the form to sign in. And if you have any questions, let any of us know. We'll also put the form in at the ending of this meeting, but I will kick it off now to Jenny, and also Tucker and Paloma are here from IEC staff if you have any tech issues and want to message them with any questions. But thank you so much for joining us for this Lunch and Learn.
Thanks so much, Jen. I really appreciate the intro. Yeah, well, y'all, thank you for joining us. There's never a dull moment in the land of coal ash. And so wanted to welcome everybody to some updates. I'll also be providing a little background because not everyone is there's no good word. I can't say steeped. I can't say, breathes it in every day, because all of those things are bad. So not everybody focuses their practice on coal as much as I do. So I will make a little bit of background before we get to the updates. Let's see. All right. So on that point, why do we need to care about coal ash? It's dangerous. Coal ash contains heavy metals, arsenic, lead, mercury, chromium, sort of a buffet, unfortunately, of heavy metals and other pollutants that can be harmful to humans, plants, and animals at concentrations that exceed protective standards. And yes, US EPA and Illinois EPA have determined those protective standards, so we actually know what they are. Unfortunately, because of the nature of coal ash pits, coal ash is very often, all too often, soaking in groundwater. Coal ash is left when you burn coal. And as many of you may know, coal plants are often located next to rivers or lakes or other large sources of water because they need that water to cool their equipment, right? So they were located there, and then they had all this gunk, right? Boiler slag, bottom ash. Once we started putting on air pollution control to these sites, they started collecting fly ash as well, which otherwise would have gone up the stack as particulate matter. So they started collecting all of it. And initially, there really weren't rules for this stuff, right? So they would just sort of dig big old pits, often next to the plants, which were often, as I said, next to rivers or lakes, and dump the ash in. And very often, unless those pits were constructed really recently, they are not lined with anything like a liner that is adequately protective according to US EPA. With that, for those reasons, coal ash is all too often soaking in groundwater, like tea in a tea bag. The pollutants in coal ash leach out water, which can then contaminate drinking water wells, wells that are used for animals, creeks, rivers, and lakes, as groundwater generally flows towards water bodies. Per US EPA, some metals continue leaching out coal ash for hundreds of years or more. Also, because of the location of these pits, many of the ash pits or ponds are in floodplains, meaning floodwaters can overtop or destabilize pond dikes, or can raise the groundwater levels due to the hydraulic connection between groundwater and surface water. So more groundwater raises up into that coal ash. Some people think that coal ash is only a problem for water pollution. Not so. Coal ash also poses an inhalation hazard when dry and exposed to wind. Folks like the TVA cleanup workers who were hired to clean up the coal ash that spilled and then dried out after that massive spill in Tennessee in 2008 can tell you a lot more about that, unfortunately. Okay. So just to give some context for why we need to care about coal ash a lot in Illinois, Illinois EPA has told us there are at least 73 coal ash impoundments in the state. The vast majority of them are unlined. They either don't have any liner at all, or they have a quote unquote liner that doesn't actually count as a liner because it doesn't satisfy US EPA standards to prevent water getting into the ash, right? It doesn't actually stop the leaching or infiltration of water. Many of these ash ponds are in or near communities that face tons of other environmental and social burdens, what we often call environmental justice communities. Waukegan, Peoria, Joliet, and Springfield are among them. You can see a map to your right of the slide. That is kudos of Andrew Rain of Prairie Rivers Network. It's also about 4 years old. So pay no attention to the operating or closed colors on the map. They're no longer accurate, but this does show you that there really are ash ponds in Illinois that crisscross the state all the way from the furthest, from Waukegan in the north to Joppa in the far south and to east. This is a major issue, and Illinois is one of the highest number of ash ponds in the country. Yeah, so this is what the riverbank looked like on the middle fork of the Vermilion River, which is Illinois' only national scenic river for a good chunk. I think it's a 17-mile stretch of that river. This was several years ago, so this is what it looks like when heavy metals, such as those from coal ash, are leaching out. This is adjacent to the ash ponds at the former Vermilion station. And for context, this is what that river looks like, the parts that are not, having coal ash pollution leaching out into them. It's a beautiful river. Kudos to Eco-Justice Collaborative for sharing these photos. So you may notice that I titled this presentation Updates to Federal and State Rules. You may be wondering, why do I care about the federal rules? Here we are in Illinois. Why do they matter? Well, you should care for two reasons. First, the federal rule continues to apply in Illinois. A federal law from 2016, amended RCRA, allowing states to get primacy so they could seek approval from US EPA to implement their own programs. Illinois has said for a long time, Illinois repeatedly to get primacy or seek primacy, but they have not yet done so. And the mandate is that states can only get primacy if their state programs are at least as protective as the federal coal ash rule. That's not a one-time deal, right? They have to look at how protective it is when it's first adopted, but then it has to continue to be as protective as the federal standards, which are changing, which I updated, because if not, they can face withdrawal of the program approval. So under federal law, they have to be at least as protective as the Illinois regs have to be at least as protective as the federal requirements. And without primacy, the federal rule still applies. But also under our own Illinois statute, the Illinois rules have to continue to be at least as protective and comprehensive. So not just as protective as, but the scope has to be as broad as the federal rules for impoundments. So that was the Coal Ash Pollution Prevention Act from 2019. So this is why you should care. Under both federal and state law, Illinois rules have to be at least as protective as federal requirements, and the federal rules still apply. So again, for those who aren't sort of steeped in this, working in coal ash issues every day, I wanted to go ahead and provide some background so y'all have context for what we're talking about with these updates. So here are some key dates in federal coal ash regulation. 2015, so only 7 years ago, was the very first time the US EPA ever adopted federal standards for the management of coal ash. It did so under RCRA, the Resource Conservation and Recovery Act, subtitle D. Those rules are codified at 40 CFR 25750 at SEC. You may notice that that's a far cry from when these important environmental statutes were first adopted, right? We had the early 70s, for the most part, mid 70s was when Clean Air Act, Clean Water Act, NEPA, RCRA, of our sort of critical environmental protective statutes were adopted. Ash was, for a variety of heavily political reasons, left out of the picture until 2015. So yeah, that is why we have so many unlined acts that are continuing to leach pollutants into the water. I'm getting another note that my connection is unstable. Do y'all have a phone number that I can call?
Yep. I have your, I wonder if I can text it to you.
Sure, I just don't want to drop off again by, unexpectedly without knowing what to do.
100%. Let me copy it from WhatsApp and I'll text it to you. And that way.
Great. Okay. Well, let me continue and then I will look for that, Jen, if I get cut off again. Okay, so continuing on, so that was 2015. 2018, immediately after that rule was finalized, there were challenges both from industry as well as environmental groups. Of course, the industry indicated or the rule was too stringent. Environmental groups, of course, argued the opposite, that was too weak. In 2018, the DC Circuit, which reviews these RCRA rules, basically almost across the board agreed with the environmental groups that the rule was in fact too weak, needed to be strengthened, and it ordered US EPA to strengthen it in several ways. First, it said there was initially a classification of sort of 3 different levels of liner. There was unlined, there were clean liners, which were considered an effective liner, and the ponds that had clean liners were not required to close unless they were proven to be leaking. And then same thing with and then there was a third category of ash ponds, again, not very many of them, that had the composite liners that are required by US EPA that they found that really do stop leaching or at least impede it significantly. So one of the challenges that environmental groups brought was that the evidence that clay liners actually effectively stopped leaching was not nearly strong enough, and that really those ponds needed to be considered unlined for purposes of the rule. The DC Circuit agreed. The DC Circuit also agreed that it didn't make sense to allow unlined impoundment, which clearly posed to the nearby areas. Many of them were very old. Many of them were known to be not particularly well engineered, right? When they were they shouldn't wait under the rule for them to be leaking. They should close right away as soon as technically feasible, right? And then they also found that it was arbitrary and capricious for EPA to have excluded what I call legacy ponds. So those are ash ponds at no longer active coal plants. So we weren't currently receiving more coal ash, but we're still had coal ash, still had water in them. But it made no sense to not regulate those, but regulate inactive ash ponds at coal plants that continue to operate or power plants that continue to operate. So it sent EPA back to the drawing board. Lo and behold, we came upon a new administration that wasn't so inclined to be following the mandate of the DC Circuit, and instead of actually working to strengthen those protections, what we saw over the next couple of years were more rollbacks, in fact, proposed. There were some that would address structural fill and landfills, historic landfills. Those never got finalized. There was what's called a Part B rule that had a number of components in the proposal. The only a couple of which got finalized. One key one is that EPA decided that it wasn't so sure about the DC Circuit's conclusion that clay-lined impoundments couldn't adequately stop leaching, and said, hey, industry, if you'd like, you can send us another application that has a lot of information in showing that your clay-lined impoundment should count as lined and therefore wouldn't have to close right away, right, as an unlined impoundment. That portion of Part B did get finalized, and I'll tell you more about those applications later. And then they proposed a permitting rule in 2016 legislation. They had been directed to start issuing permits for these sites, US EPA as a permitting agency, in all areas where states don't have primacy over their own programs. They never finalized that permitting rule, so there are still no federal permits occurring whatsoever. The rule is still, because it was passed under Subtitle D, the 2015 rule is still, quote, self-implementing. So let's see. I was talking about some of the revisions that have taken place over the last few years in the federal regulatory scheme. One of the major ones that has come out that I'm going to focus on today is the Part A rules. So you may recall, as I noted a few minutes ago before a technology disaster, in 2018, the DC Circuit said that unlined impoundments were required to close without waiting for them to have proven leakage. And so the EPA's Part A rule, which came out in 2020, basically gave companies an opportunity to, it set a deadline for when unlined impoundments would need to cease receipt of additional coal ash and sort of commence the closure process. And then it also allowed extensions based on sort of technical infeasibility, essentially the inability to find alternate disposal capacity either on site or off site. But there was a big fat condition to that option to seek an extension for the right to continue using that ash pond. And that was that not only the ash pond itself, but the entire facility, so other ash ponds, other landfills at the site that are subject to the federal coal ash rule, that they be in full compliance with the federal rule. So those applications were submitted they were due and submitted in November of 2020. Fast forward all of 2021, nothing. Nobody's doing anything, at least nothing public. And I will take you to what happens in 2022 shortly. But yeah, so just to give folks some context for what this 2015 rule at the federal level does mandate, finally. It covers both ash ponds, so ash that's in, pits that have both water and ash in them, as well as landfills, which are theoretically dry, although we found that that's not always the case. It establishes standards to prevent catastrophic failures of coal ash lagoons, such as what happened at TVA in Tennessee in 2008, as well as to limit the leaching of toxic pollutants into groundwater and clean it up when they do find that toxic pollution. So some of the specific protections included in this federal regulatory scheme include location standards. So for example, new ash ponds can't be in unstable areas with seismic activity, wetlands, or within 5 feet of the uppermost aquifer, so the groundwater table essentially. And even existing impoundments are subject to those same standards, but only some of them sort of trigger, excuse me, the location standard triggers a closure mandate as well if you're within 5 feet of groundwater, again, emphasizing EPA's concern about this potential to leach when ash is in contact with groundwater. It also requires stability analyses, an initial one, and then every 5 years, sort of evaluating the hazard potential, the safety factor, which are all sort of geotechnical analyses that are done to evaluate the stability of ash ponds, as well as annual inspections and some more frequent inspections. It also has a comprehensive groundwater monitoring scheme where there's background well or wells, which is sort of the up gradient, so kind of upstream of this subterranean water, background water to measure the water that is not impacted by coal ash pollution, as well as downstream pollution, so down gradient of the ash ponds, to measure the difference, right? How much arsenic is in the background versus how much arsenic is in the down gradient wells. Let's see what it looks like is being contributed to from the ash pond or ash landfill. It also has corrective action mandates. So if you do find this pollution in the groundwater at statistically significant levels or increases above background, there's sort of a two-tiered scheme. You have to first, if you find some pollution in groundwater, some of the pollutants, you trip to another scheme that adds a whole bunch of other pollutants you need to measure for. And then if those are found at statistically significant levels, then then corrective action, so cleanup needs to be evaluated and begun, except for if you can prove that another source was in fact the culprit of that contamination. Fugitive dust protections, like I mentioned before, the air concerns with coal ash, as well as one of the things we're gonna focus on today, which is closure and post-closure standards. It's self-implementing, as I mentioned. It's not designed as a permitting program. There are no permits. There's very little public participation. There's a public website where a lot of documents have to be posted to a single meeting, and again, this enforcement option. There's also no financial assurance, which is sort of code word or tech speak for bonds or letters of credit or other sort of cash money, right, set aside to make sure that the funding is available for cleanup and closure or other need for that to ensure that this pollution is halted. Next slide, please. So now, bringing it down to the Illinois context for some background. So in August 2019, Illinois adopted the Coal Ash Pollution Prevention Act, which amends the Illinois Environmental Protection Act. So the context of that was, of course, we had the federal rule 4 years before that, and we had the DC Circuit opinion the year before. And we knew that there were a whole lot of unlined impoundments in Illinois that were going to have to close pronto under the rule and the subsequent decision. And the legislature recognized that concern, as did the governor, and we adopted this this legislation, thanks, I should say, in large part to the late Senator Scott Bennett. In April 2021, the Illinois Pollution Control Board issued rules implementing that Coal Ash Pollution Prevention Act, which are set out at 30 Illinois Admin Code Part 845. And the board opened a subdocket to address some topics, including historic coal ash fill. I'll let y'all know where that stands later on. May 2021, so you may notice exactly a month, and it was actually only a couple weeks after the rules were finalized in Illinois, all of a sudden there was just a slew of petitions to get out of jail free, to say, we think our impoundment is different and should qualify for its own set of rules, or how about just none? So for several of those, quote, adjusted standards, the entity seeking those standards wanted full exclusion from Part 845 for their impoundment. For others, they wanted simply certain provisions not to apply to them. And a key thing to note about these adjusted standard petitions is that under Illinois law, those stay the provisions from which they seek adjustment, right? So for some of these sites, none of the rules, including the permitting deadlines or anything, applied while these, or apply, I should say, while these adjusted standards are pending, which 6 out of the 8 that were filed in May 2021 remain pending. So another date just to have on hand is when permit applications started going in. There were 3 sets of permits set out in the rules. One of them was closure, one of them was corrective action, and one is operating. Operating covers things like groundwater monitoring, fugitive dust protections, structural stability, inspections, etc., which are sort of ongoing obligations at the sites. For essentially every impoundment in Illinois, save a few that got variances. Those were due October of last year. Next slide, please. So just a quick context of the governing law here in Illinois, Coal Ash Pollution Prevention Act, again, amending the Illinois Environmental Protection Act. It mirrors the federal scheme. It establishes those, same location standards, design standards, operating standards, groundwater monitoring, closure, et cetera, except for it does so under a permitting construct. So it establishes permitting requirements for cleanup, closure, and operation of ash ponds with public comment and public hearing mandates. It instructs the agency, so the permitting agency is the Illinois EPA, to prioritize the closure of and the Pollution Control Board, as it adopted this rules, to prioritize the closure of high-risk ash ponds and those in environmental justice areas. Unlike the federal law, it requires financial assurance for cleanup, closure, and post-closure of these ash ponds, so that continued groundwater monitoring, for example, an inspection of caps that will take place at those ash ponds that are, quote, closed in place with a cover, without self-bonding. So it does really actually, put some money aside to make sure that those things are done right. And the rules, the statute directed Illinois EPA to propose and the Pollution Control Board to adopt rules that are at least as protective and comprehensive as the federal rule, with a few additional mandates above and beyond that. Next slide, please. So I think this is mostly, I just explained to y'all what the rules cover, so I will skip this slide. Just a few notes on some of the provisions of the Illinois coal ash rules that do go above and beyond federal mandates. There are some differences in the way groundwater monitoring is required in our state that are not in the federal rule. Monitoring is required more frequently, so quarterly, which means that pollution can be detected more quickly. Unlike the federal scheme that has that sort of two-tiered scheme of monitoring all of those pollutants, in the quote Appendix 3 and Appendix 4 of the federal rule, which includes the full suite of heavy metals, are all monitored every period, with a few limited exceptions that may kick in several years, but at least from the get-go, they were all monitored. And then nearly all of these pollutants trigger cleanup if they exceed protection standards, which the first set of pollutants under the federal standards don't themselves trigger cleanup. And again, the difference is that unless the background concentration is greater than the protection standard, there is no statistical analysis that needs to be completed. It's simply exceedances of the groundwater protection standards with confirmation trigger cleanup. Something else we fought hard for in this law was transparency, comparison of different methods of closure, including in every circumstance, an evaluation of removing the ash as the method of closure. And then what would you do with that ash after you remove it? So we wanted to include, and the law does include, as do the rules, review of transport options for excavated ash, including rail, barge, low polluting trucks, which y'all may have heard are starting to be a thing around the country, and we're fighting for them here in Illinois as well, and a combination thereof. Or a combination thereof, I should say. And then transparency provisions also include sort of a vast array of documentation that's submitted with the permit applications to show how the site will satisfy the requirements. And those have to be included in the applications and posted on public websites. One additional way it's more protective is stability analyses and certifications are required annually rather than every 5 years. Next, please. And I will skim over this real quick, basically because the federal rule includes essentially no public participation. Our permitting program, which requires participation both before applications are submitted, broad notice, access for non-English speakers, and 45-day comment periods, an opportunity to comment on alternate source demonstrations, which is when the owner wants to say that a different source causes pollution, not its ash pond. Those are all above and beyond, by a far cry, the federal rule in terms of public participation. Next slide, please. So that's the background. Sorry for rushing through it, given the technical challenges. Now what you came for, what's actually happening now? Updates on federal and Illinois regulatory schemes. So what's new in federal regulation? The sort of biggest news that has come out over the last year are EPA's determinations on these Part A applications. So you'll recall those are applications to essentially extend the operating life of ash ponds. Those were submitted in November 2020. There were 57 of them, including 10 in Illinois, one of which has since been withdrawn. In 2022, starting in January, EPA finally took action on 12 of those applications, proposed to find that 4, including one in Springfield, were incomplete and therefore didn't qualify for the extension. One is entirely ineligible. It proposed to deny 3 of the applications and to conditionally approve 4 applications. You'll note that none of these were proposed to be approved without conditions. A couple months, I want to say it was April, I believe, of this year, there was a lawsuit filed by some companies here in Illinois and elsewhere to challenge EPA's proposed, yes, I did say proposed Part A decisions, a press release on those proposed decisions, and some letters that EPA had sent to companies and state agencies pointing out noncompliance with the rule. Briefing is underway. Full disclosure, I'm an attorney in that suit, so I will leave that there. Next slide, please. Okay, so sort of the biggest, most recent news is that last month, November, US EPA issued its first final decision to deny the application to extend the life of ash ponds at the James and Gavin plant in Ohio. So the implications of that decision are that Gavin has to cease disposing of coal ash in its ash ponds by 4/12/23, April 2023, unless reliability determinations, electric reliability determinations dictate otherwise. Next slide. Brief interruption of our regularly scheduled programming. Figured y'all could use another picture to liven up your day. So that's Gavin. Just in case that sounds familiar, it might be because in 2002, former owner AEP bought the town for $20 million after widespread complaints about air and coal ash pollution. We can put a pin in that one for another day and get back to our normal programming about coal ash pollution. Next, please. All right, back to Illinois, the Gavin plants in Ohio. Why should you care? Well, you should care because other than a couple consent decrees, the Gavin decision, the Part A decision on the Gavin plant, is the first time EPA has issued a final binding decision that applies the federal coal ash rule. The Gavin decision reveals how US EPA interprets the federal coal ash rule as it reviews far too many remaining Part A applications, as well as evaluates compliance with the rule nationwide, including in the few states that already have primacy, which are Georgia, Oklahoma, and Texas. You should also care because the non-compliance EPA found at Gavin is not at all unique to that site. EPA identified similar violations in proposed Part A decisions. And in a review of utility coal ash compliance documentation, that is the monitoring that industry itself does, right? Environmental Integrity Project. And my organization, Earthjustice, found widespread noncompliance with these provisions in a report that was released last month. Next slide, please. So you want to know, you're dying, you're at the edge of your seats. What does US EPA say in its Gavin decision? It says coal ash must not remain in contact with groundwater after closure. EPA goes into some detail about the closure standards. Oops, there's one that I forgot to fill in. But these are the closure performance standards and other standards that are required for the types of closures that can take place. So the two options for closure under the federal coal ash rule are closure by removal, which is where you excavate the ash and either move it to a landfill on site, move it off site, potentially use it for, quote, beneficial use elsewhere, such as use in lieu of cement and concrete, for example. Or you close it in place, which is where you drain all that ash, you get all that water out, and you place a protective cover over it, and then you continue to do groundwater monitoring and inspections and various other maintenance activities for at least 30 years after putting that cap over it. So there's been a significant amount of controversy, as you may imagine, about when those, how those standards work and when they must be applied. Well, EPA has really clarified here what the rules require. It's really, applied these rules to explain what they mean and what they have meant under EPA's interpretation since they were adopted in 2015. So EPA says these closure mandates, performance standards, must be met at every unit, and they collectively operate to prevent liquids from migrating into the unit and to prevent contaminants from migrating out of the unit after closure. EPA, and I quote, is unaware of a circumstance where these standards could be or have been met when the waste in a closed, unlined impoundment remains in contact with groundwater that freely migrates in and out of the CCR, the coal ash, remaining in the closed unit. It also clarifies, which again it was already clear in the rules, right? But it elaborates on the elimination of free liquids mandate in the coal ash closure standards, saying that in situations where the waste in the unit is inundated with groundwater, the requirement to eliminate those free liquids thus obligates the facility to take engineering measures necessary to ensure that the groundwater, along with other free liquids, has been permanently removed from the unit, so can't continue to flow back in prior to the installation of the final cover. It also makes reference to the protectiveness standard under RCRA, that is the governing standard for these regulations. It says allowing groundwater to continue flowing through the coal ash would not protect human health and the environment. So if you learn nothing else from this entire presentation, remember the coal ash rule at the federal level, and hence Illinois, because of what we discussed earlier, coal ash may not remain in contact with groundwater after closure. Next slide, please. Couple additional important notes that are included from US EPA in its Gavin decision. It really goes after what it sees as inadequate groundwater monitoring. You'll remember that the monitoring is, of course, what determines whether pollution is found and therefore whether it's cleaned up. And if you're not monitoring properly or you're not monitoring enough, you're going to miss that pollution, and therefore it's going to remain in the groundwater, potentially getting into surface waters. So EPA really goes to town on how the background wells have to be properly determined to ensure that they are not, in fact, affected by leakage from coal ash ponds or landfills, because under the scheme, if the background well, that is the point of comparison for the down gradient well, is contaminated, it's going to mess up the whole comparison and potentially mask contamination from the units. So it takes a page or two to talk, to write about that and to clarify or just elaborate on the fact that these background wells really need to be properly cited to make sure that they don't monitor groundwater affected by coal ash units. EPA also goes into a lot of detail, which is something it did in other proposed Part A decisions, about how Gavin's groundwater monitoring program, its whole system where it has the monitoring wells is just not adequate. It didn't adequately characterize which ways and which directions groundwater is flowing, the flow rates. It didn't adequately evaluate the different levels of groundwater at the site. Albert, I'll get to questions in just a moment. So what EPA says is, while the requirement in the rule is to have a minimum of 1 background well and 3 down gradient wells, the presumption is that that's not sufficient. And at a facility like Gavin, where it has a multiple many acre ash ponds, having only a few wells is simply not going to actually catch all the groundwater pollution and thus leave contamination in the groundwater because it won't get cleaned up. The number and placement of the monitoring wells, I quote, is critical to proper characterization of the groundwater. Next slide, please. Another important thing is alternate source demonstrations. This is the pointing the finger at another source. Simply, EPA makes clear that simply blaming another source without really backing that up with site-specific facts and data is not adequate. You have to show that the unit is not contributing to contamination, and sort of geochemical comparisons that have been used in a number of instances to, quote, prove that the groundwater contamination could not be coming from the impoundments are not permissible evidence to support that assertion. Next, please. A couple other new things in the federal regulatory world. There was a lawsuit filed in Alabama in September challenging an Alabama an approved plan at an Alabama power plant, Plant Berry, to close an ash pond in place as a violation of the federal coal ash rule for the very things that I discussed earlier in terms of groundwater being in contact with that coal ash. That suit remains pending. And then just this past month, Appalachian Mountain Advocates and Earthjustice, on behalf of a lot of organizations, including some here in Illinois, sent a notice of intent letter to sue the Office of Surface Mining for failure to respond to a 2015 petition to regulate coal ash dumped in mines, which is not regulated under the federal or state coal ash rule. So those remain pending. Next slide, please. Really quickly, there's not a whole lot to say about where we are now in Illinois. So I will give you the update, which is that closure applications were submitted for a number of ash ponds back in February. Those are, again, for those top priority ash ponds in areas of environmental justice concern, and active ponds that are polluting and others that pose imminent risks. Those were submitted in February 22. This is following the October 21 operating permit applications. And then there were a few more permit applications that have been submitted over the summer. So what's the update, you might ask? What is going on with these? Oh, well, as of yesterday, and I'm pretty sure today, there have been 0 draft permits, whether operating or construction, issued by Illinois EPA. There have been counted 0 final permits issued by Illinois EPA. Of those 8 adjusted standard petitions, there have been 2 that have been resolved by the Pollution Control Board. Well, they did actually hit all 3 of those variances. Those are temporary deviations from the rules. Those have been resolved. So you might ask, what is happening? Well, most of IEPA's apparent energy and resources have been seemingly dedicated to these adjusted standards, just trying to get companies to comply with the rules that that should have applied to them from the get-go, or at least in some of these EPA so contends. So in Waukegan, Illinois EPA filed a recommendation with the PCB, the Pollution Control Board, to deny the adjusted standard, which would exclude from the Part 845 rules an ash disposal area that IEPA says is parts of an old ash pond. There's a response due in April. In Joliet, there's a few, there was hearings held this summer relating to a couple aspects at that plant, including whether or not the liner will need to be, the liner that doesn't qualify as a liner under federal or state rules will need to be removed as part of the closure of that site, among other issues. Post-hearing briefing filed, I believe that is awaiting decision. There was a recommendation from Illinois EPA in those an adjusted standard for the Marion plant that was due yesterday, and apparently just a couple days ago got kicked to January 13th. There are others where there's plans to file amended petitions, and another one is stayed. So not a whole lot would be the summary answer of what's going on in terms of Illinois regulations. Near final slide, please, if you would. The subdocket, you may wonder, I had mentioned the subdocket before, where the Pollution Control Board agreed to explore 4 different areas that it had sort of incompletely looked at or didn't feel comfortable issuing regulations about, or wanted to, look more about potentially issuing more regulations. Those include piles, fugitive dust monitoring, determining which areas are environmental justice areas, and regulating historic ash fill. Again, that is pending, no final regulations, and nor indeed have any first notice regulations yet been issued. So it is pending. And I will stop there. I'm sorry, we're not that much time for questions, but there is time for some.
you
I
do have
believe,
questions,
Albert,
yeah,
you would ask. Oh, I'm sorry.
I was just going to say, if you do have questions, feel free to either use the raise your hand function in Zoom or put them in the chat. And then you should be able to take yourself off mute as well to ask questions. But yeah, go ahead, Jenny.
Sure. I was just going to ask, I don't, Gavin, I believe, is still operating, Albert. That's why it's asking to continue to use its, at least one of the ash ponds that's at that site. And the federal rule, it does apply to closed lagoons when they are at operating power plants. That's the quote inactive ash ponds that are at operating power plants. And it does not yet, I should say there have not yet been regulations issued for the legacy ponds, even though in 2018, the DC Circuit told EPA it needed to regulate them. So there are some states, including Illinois, where we have included those within our state scheme, right? So in Illinois, legacy ponds, so closed ponds, or not closed, but inactive, no longer receiving ash ponds at retired plants are regulated. And a few other states have taken that same approach and interpretation of the DC Circuit's decision, but EPA has not yet issued those regs.
Thank you.
You're welcome.
Any other questions, folks? Now's the time.
Well, if nobody else is going to ask a question, what do we do about the situation in which it's clear that the ash pond is flowing into a water body? Has the regulation on that changed? There was a whole series of litigation, of course, which I think you were involved in too, regarding whether or not that was a discharge. Is that been worked on at all, and how do they deal with that under the new regulations?
So that's right, Albert. So there was the 2020 decision from the Supreme Court in the County of Maui case, in which it held that in certain circumstances, groundwater discharging into surface water bodies could be, or water that wasn't coming from quote unquote a sort of what was historically understood to be a point source like a pipe could be regulated under the Clean Water Act. So that is sort of separate from the RCRA regulation, but I believe there's still several pieces of ongoing litigation related to those circumstances when groundwater discharges into surface water, fall under the Clean Water Act and therefore all the standards that you know very well.
But there haven't been any new cases since the Supreme Court decision that dealt specifically with this problem of coal combustion waste getting into surface water.
I know there have been cases that have addressed that issue, but I don't know the status of that. I was focusing on RCRA, but I can check into that for you.
That's okay.
Get back to you.
Okay. I was just, thank you.
Not a problem. The Vermilion ash ponds, great question. Sure. Well, the state filed an enforcement suit in June, I believe it was 2020 at this point. My dates are getting a little bit messy, in which there was an agreed order and the company that owns those Vermilion plants agreed to close those ponds by removal. So that was June 2020. You might ask, of course, what is the status? Well, Vermilion, the owner of Vermilion did submit their closure permit application by the date for those prioritized ponds, like those ponds. That was February of this year. And we have seen, as with all other permitting activities, zero action on that request for a permit to close its ash pond by removal. So unfortunately, there's not a whole lot. There's some, monitoring that's ongoing for stability purposes, given that the river is eroding the riverbanks next to the ash ponds. And there's, some discussion of interim corrective action that the state has agreed to with Dynegy, the owner of the Vermilion plant. But that permit application is sitting on someone's desk at Illinois EPA, as far as I can tell.
All right. Well,
And I
thanks,
should-
folks. I think. Oh, sorry. Go ahead, Jenny.
I was just going to say, I should clarify, I'm also counsel in that case too. So I represent the views of Prairie Rivers Network, although what I just said is, it's hard to dispute those facts. Thanks.
That's fair. Thank you so much, Jenny. I know I personally learned, I learned a lot. So thanks so much for sharing your expertise. And as a reminder, I think Paloma's been putting in the chat the opportunity to add your name if you're an Illinois attorney seeking CLE credit. Go ahead and put your name there, and we'll get that certificate to you, I think, out in the week. There also is another one of these Lunch and Learns eligible for CLE credit coming up, I think, on the 20th. And Paloma also put the registration page in there. We'd love to have you join us for that one too. I think it's going to be maybe I was trying to think of the sports and out doubleheader. I don't know. Jenny, you'll be joining us again for that one, I think. So, yeah. So, folks,
Not
please
me,
do
but
that.
my colleague Debbie.
Okay, cool.
Thanks too. Thanks,
Yeah.
Becca. Yeah.
Yeah, sure. Thank you so much. And, we always appreciate it. We started this series around the time that the pandemic initially started, and it's been a great way to connect. And it's been such a great opportunity to partner with other groups like yours, Jenny, and have everybody join us. So we appreciate it. If you have a little support to spare, please, consider donating to IEC. That really goes a long way in supporting our work and making this kind of programming possible, as well as all the other things we do. So thanks so much. Again, and we can send a follow-up email as well with the presentation and a link to this recording. Yeah, Jenny, maybe you could drop your email address in the chat in case anybody has any follow-up questions there. And I think that's it for us, folks. Have a great weekend, and yeah, take care.
Thanks very much. Bye-bye.
Thank y'all for coming.